Welcome back to Introduction to Law Swift course. Now that you have a picture of what the law is, we move on to its deeper roots. I'm sure you've heard the phrase, I have a right, or something along those lines. Let us define what a right is. In simple terms, a legal right is something that is recognized by the law that a person or group is allowed to have or do. This recognition is given to individuals or entities, like organizations, that can legally hold these rights. These are called legal subjects. These rights are related to a specific thing or purpose called a legal object, and they come from the legal capacity of the person or group involved. So it's like saying the law acknowledges certain things people or organizations are allowed to have or do in connection with a particular legal matter. In order to understand rights further, we have to know what a legal subject and a legal object is. Legal subject. A legal subject is anyone who is subject to the norms of the law and may be the bearer of rights and duties. A legal subject has a legal capacity of forming legal relationships. In South Africa, there are two categories of legal subjects. Number one, natural persons, which is normal human beings just like you and me. Number two, juristic persons. These are associations of natural persons such as companies, universities, political parties, unions, etc. As aforementioned, legal persons have legal capacity to form relationships. This capacity differs with legal subjects. There are 4 levels of legal capacities. The first type is called legal capacity. This can be described as a legal subject's ability to bear rights and duties. It is therefore essentially the same as legal subjectivity, because it is acquired through being a person. In other words, all legal subjects have legal capacity simply because they are recognized by law as persons with rights and duties. 2. Capacity to act. This refers to a legal subject's ability to perform juristic acts. Juristic acts are purposeful, lawful acts to which the law attaches the consequences envisaged by the party or parties who perform them. Juristic acts create, amend, and terminate rights and duties. Examples of juristic acts are the conclusion of a contract, the making of a will, the entering into a marriage, etc. Contrary to the situation with legal capacity, where all legal subjects share the same capacity, not all legal subjects have the same capacity to act. Depending on factors such as age, mental health, financial solvency, etc., a person can have the capacity to act in terms of 3 categories. Category A, no capacity to act. Persons that fall into this category cannot perform a legally valid juristic act. Children under the age of 7, infants, and insane persons are the examples of legal subjects with no legal capacity to act. B, limited capacity to act. Some legal subjects do not have the capacity to perform legal acts unless assisted by someone designated by the law. For example, a company cannot hire a new secretary by itself since it is merely an abstract entity. It has to be represented by the people who are designated to hire new staff on behalf of the company. C, full capacity to act. People with full capacity to act can perform all juristic acts themselves. People over the age of 18 and emancipated minors are presumed to have full capacity to act. Number 3. Locus standi in judicio. This entails the capacity to be a party in court proceedings, for example, the plaintiff or defendant. Although not all legal subjects can exercise their locus standi in judicio by themselves, it does not mean that they are without this capacity. Persons who cannot participate as a party themselves are usually assigned a curator to represent them as parties in a trial. Number 4. Accountability. Accountability is the capacity to be held accountable or liable for unlawful acts. It concerns the ability to distinguish between right and wrong and to conduct one's actions accordingly. Persons who do not have this ability are considered to be doli incapaz. In terms of the aforementioned explanations of legal subjectivity, capacity, and the four kinds of capacities, it is clear that all legal subjects have rights, but depending on their capacities, the content of their duties may vary.